So, two cases challenging the NFA and its restrictions on SBRs were seeking Supreme Court review. And now we have the Supreme Court's answer, and it's not great. Like the machine gun ban challenges, the Supreme Court has decided to deny immediate review to these SBR cases. So let's talk about what happened and what happens now going forward. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. Also double check to make sure YouTube is not unsubscribed you, because I love to do that, especially on two-way channels. I also want to thank one of the main supporters of this channel, which is First Form. You guys know that First Form is an amazing company. They're pro-freedom, pro-America. They support the Second Amendment and what we talk about here on the channel. Plus, they have great supplements. So if you're trying to get healthier, maybe have a New Year's resolution, check them out using the link down below. And if you use my link and order any supplements, you will get a free 5-pack of protein sticks. Now, as I mentioned in the intro, in this video, we're going to be talking about a very important, case and challenge that was in front of the Supreme Court. It's actually two cases dealing with the SBR restrictions under the NFA. These cases, US versus Rush, and then also the Robinson challenge, are challenges to the NFA and its SBR restrictions. These challenges ask for the Supreme Court to step in and find that the NFA's restrictions are unconstitutional under the Second Amendment. The petition also focused on how the Supreme Court finally needed to step in to correct lower court confusion and defiance on what type of arms are protected under the 2A's text. Recently, we got a response from the Trump administration, and in response, they argued that the Supreme Court should deny review to these cases because they believed the NFA has at least some circumstances where it's valid, and therefore it should survive a facial challenge, and any facial challenge should fail. And even more interesting, they also argued that the underlying question on whether or not SBRs are arms and therefore protected is a question that should be answered in a different case. The Trump DOJ called for the Supreme Court to take up a state AR-15 ban to further outline that topic rather than this SBR challenge. Well, today we got the response and answer from the Supreme Court, and they have denied review to both of these SBR challenges. However, this issue is not done yet, so we need to talk about what happens in these challenges going forward and what happens in this issue also going forward. Now, for those not aware, in this case, the one we're going to focus on is the Rush challenge. It was a challenge to a possession issue where the individual here was possessing an unregistered SBR in violation of the NFA. So essentially, in February of 2022, an officer saw that Mr. Rush, who didn't have a driver's license, had been revoked. The officer saw him pull into a driveway with his truck and walk into the courthouse across the street. And he was, I believe, making a court appearance. Now, after leaving the courthouse, he walked across the street, went into that nearby apartment complex where his sister lived, and about an hour later, his sister left the apartment, jumped in his truck, and started to drive away. Now, the officer decided to stop the truck, asked his sister to call her brother, Mr. Rush, and the officer spoke with him on the phone, and Mr. Rush admitted that he did drive the truck to that location and that he would come out and talk to the officer. Now, while that was happening, the officer also looked into the vehicle and he saw what he thought was marijuana in the center console. And because of that, the officer began to search the truck. Now, Mr. Rush arrived about that time. And when he arrived at the vehicle, he opened up one of the truck's back doors and reached in to grab something. Now, he was detained, arrested. And later, when they searched the vehicle, they found an SBR on the floorboard of the truck. And Mr. Rush admitted to the officer that he intended to grab the rifle and then run away. Now, because of this, Mr. Rush was charged with possessing an illegal SBR in violation of the NFA. Now, Mr. Rush argued that the NFA's registration and requirement restrictions infringe on his 2A rights, and therefore those charges should be dropped. The district court on review denied that motion, concluding that SBRs are dangerous and unusual firearms and therefore not protected by the Second Amendment. This then was appealed to the Seventh Circuit, who on review affirmed the lower court's ruling, relying on the Supreme Court's precedent in US versus Miller. The Seventh Circuit found that Miller still remains controlling precedent and that the NFA's restrictions are consistent with the historical firearms traditions in the United States. This then led Mr. Rush to seek Supreme Court review, and in his petition to the Supreme Court, he asked for them to reverse that lower court ruling and strike down these NFA SBR restrictions. Now, like I mentioned, the Trump DOJ originally decided to waive the right to respond to the petition, but the Supreme Court ordered that the Trump DOJ file a response. And in that response, the Trump DOJ argued that the petition should be denied because the NFA is facially constitutional. They argued there is some valid applications of the NFA when it comes to the Second Amendment context, and therefore it survives any facial challenge. They also argued that this case is not the proper case or vehicle for reviewing the broader question about what are protected arms. They argued instead the Supreme Court should take up a state rifle ban case to answer that question, but not this SBR challenge. Now, Mr. Rush, in response to that, stated that this court's precedent makes clear beyond doubt that the Second Amendment's plain text extends prima facie to all instruments that constitute bearable arms. Yet the Seventh Circuit's panel below denied that the NFA's registration and taxation requirements for SBRs even implicated the Second Amendment's plain text. When the lower court's Second Amendment jurisprudence deems ordinary long arms to fall outside the text of the Second Amendment altogether, that is a sign that the jurisprudence has taken a dangerously wrong turn. This court should therefore intervene. Here in Mr. Rush's response, they start by pointing out how far lower courts have gone to twist Bruin and other Supreme Court precedent to protect these types of two-way violations. He concluded by stating that this case presents the court with an opportunity to address and resolve one or more of those questions in the context of an anomalous federal law that restricts the possession of common firearms that no one can plausibly claim are unusually dangerous or especially susceptible to criminal misuse. Therefore, this Supreme Court should grant the writ here. Now, despite that, as I mentioned today, we got the answer from the Supreme Court in their order list, and the Supreme Court has decided to deny review to both the Rush case and also another SBR case called the Robinson case. Now, that is not entirely surprising that they denied review to these NFA SBR cases. They typically will try to avoid these types of issues. Also, we saw recently that the Supreme Court immediately denied review to the GCA Morgan case, which dealt with machine gun bans, and they did that last week. So after a winter conference, the following Monday, like this one, they denied immediately review of that case. So I anticipated that these NFA challenges would kind of suffer the same fate, and that's exactly what happened. However, another interesting development is that the Viramontes state rifle ban case coming out of the state of Illinois, that challenge and also the Duncan California magazine ban cases survived another conference and they have been relisted once again. Now that might mean absolutely nothing. It could mean simply that they're just being pushed out because they're going to be denied down the road and maybe someone is wanting to write a dissent. So maybe something like that is happening. But also it could indicate that if the Supreme Court had zero interest in those rifle ban cases, in the magazine ban cases, they could have just simply outright kicked those cases like they did with these NFA challenges and also the GCA case. So there may be a silver lining with seeing these NFA cases get kicked immediately and also the GCA cases get kicked immediately after the first conference, that maybe the other cases dealing with rifle bans and magazine bans have a better chance. Now, despite the denials in these cases, the NFA issue is not yet over. There are other cases currently moving in the lower courts which are challenging the NFA based on the new $0 tax change that happened in the Big Beautiful Bill. Those challenges are a little stronger because they are leveraging the recent congressional changes to the $0 tax on NFA items like SBRs and suppressors, and they're trying to expand upon that to eliminate all of the remaining restrictions. So even though these two cases were denied review by the Supreme Court, there are other challenges which may be a little bit stronger that are still moving their way through the system. But unfortunately, these two NFA and SBR challenges were denied review by the Supreme Court today. But again, not all hope is lost. We will now keep our eyes on the other NFA challenges that are still in the lower courts, trying to leverage the $0 tax change, and also on the rifle and magazine ban cases that have been relisted by the Supreme Court. And we're going to see, what does the Supreme Court want to do with those challenges? Are they maybe going to take up the arms ban question in one of those cases, like the rifle ban case, similar to what the Trump DOJ called for in this Rush and Robinson challenge dealing with the SBR restrictions? So we're going to see how that develops. As we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All those things help to fuel the algorithm. You can also check out one of the two videos here on the screen that the YouTube algorithm thinks that you'll find helpful. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.